Hello everyone, welcome to our Egyptian online seminar group. First, keep your phones off. Then, if you have any questions, you can ask our speaker during her presentation or after her presentation. I have great pleasure of welcoming here Professor Kristen Valentine. Kristen is an associate professor of accounting at the University of Georgia. Her primary research area explores how accounting and disclosures influence innovations. She also examines the factors that influence managers' voluntary disclosure choice, disclosure regulations, and real earning management. Her work has been published in top ranking journals, including the Journal of Accounting and Economics, Journal of Accounting Research, the Accounting Review, Contemporary Accounting Research, Review of Accounting Studies, and the American Business Law Journal. She earned her PhD at the University of Texas at Aston. Now we will start our seminar with dear Professor Kristen Valentine.
Oh, thank you so much, Mohamed, for the honor it is to be invited to this forum. I've seen these invitations since the pandemic, and it's so great to have this international platform. I know my co-authors, Jenny at UBC and Wushang, currently at University of Akron, headed to Rutgers Camden, and who kindly joined today to set the record straight. I know we're all very grateful for the opportunity to get some more exposure for our research and get some feedback as well. So this project started where I think Wushang was Jenny's PhD student at UBC and had a great idea that they had initially proposed they had a proposal and a preliminary paper at a work conference that I attended. And I got really too excited as a participant and asked too many questions. They were kind enough to invite me to join the project, which I was more than happy to do because it's a brilliant idea. I can say that having not initiated it myself, but I also love working with this team because they have the good sense to have last names who are after the alphabet for me. So I am on very few times in my life, the first listed author. So here's hoping it gets published. So just a quick overview, since I know the paper may not be accessible. And after my overview, feel free to interrupt with any questions. But the first research question, the main research question we ask in our paper is, do firms strategically disclose scientific publications in areas where they lag competitors in response to increased technological competition? So there's a lot to parse here. So the disclosure of scientific publications, what we're referring to here, is this notion that publicly traded corporations in the United States have a lot of R&D scientists and individual inventors, and they are actively participating in the scientific academic publication process. So, publications in Nature or Science could have authors that are affiliated with these public corporations. So this scientific publications could be a strategic disclosure channel. So that's what we're referring to here. And then we're looking specifically by technology area within a firm. So firms could be operating in multiple different innovation categories. And so we're specifically talking about areas where they might lag behind competitors. And what do they do with their scientific publications in response to increased technological competition is our main research question. So why might firms engage in this strategic disclosure behavior? Well, publicly disclosing the technical details in a scientific publication, right? You're going to enumerate the experiment that you ran and its results and kind of describe the mechanism that you think is happening behind the result. This is highly proprietary information on firms' early stage R&D endeavors. So there are significant proprietary costs here, but it might be a strategic choice to incur those costs and disclose anyway, if doing so precludes your competitors from obtaining a patent on that same kind of technology, right? If we're thinking of this space where there are multiple competitors in a given area competing for a similar invention and competing for a patent on that invention. And the benefit is if you are lagging behind your competitors, if you think, hey, I don't have a shot at getting that patent before my competitor does, the next best thing you can do, aside from seeking patent protection, right, and winning, if you're not able to do that, the next best thing you can do is at least keep that technology in the public domain so that you don't have to pay royalties to your competitor in order to keep using that technology. So that might be the strategic choice here. And how do we do that? We use difference in differences regressions examining firms' scientific publications by their specific technology area around the America Invents Act. So this was an act that applied to US patent grants in 2013. So that's kind of the shock that we have there. And our unit of analysis is the firm technology area year. So again, we can look more granularly than our typical firm year and decide what areas they're disclosing in, which is kind of an important feature, I think, in our paper. So quick preview of the results. We find that firms do indeed increase their scientific disclosures in their lagging technology areas after there's an increase in technological competition due to the AIA. What's really also interesting is that peers' patents in those same technology areas are rejected more often by the patent office after the AIA. And so that kind of shows that the strategic disclosure appears to be effective initially, at least. And the patent office, actually, it's nice we can look at why the patent office rejected the competitor patent and pinpoint that it is due to them lacking, the invention lacking novelty or being obvious given the prior literature there. Okay, so that's my overview. Again, at any point, feel free to jump in with questions going forward, but hopefully that provides a little context to where we're headed today. So overall motivation, I think what's one of the new things about this paper is we're looking at for-profit corporations and their affiliated employees actively publishing in academic journals. So Elsevier, which you may be familiar with, publishes some accounting journals as well. But in 2020, of the 560,000 different publications under their umbrella, 22.5% of them had affiliated authors with for-profit corporations. And if you go through on the Nature Index and rank the top publishing entities, you'll see IBM Corporation, right? A US publicly traded firm that is usually at the top of the list, or close second on the total number of patents granted every year, is number 80 on this list. So this is Aurora et al. 2021, kind of highlight this data initially, but there really hasn't been any evidence about using these types of publications as a disclosure channel, especially when it comes to strategic disclosure. That's kind of the setting, and then some motivation from where we are, I think, in the academic space. So typically, when we've looked at the type of competition and voluntary innovation disclosure, when we're speaking about technological competition, as opposed to maybe product market competition, prior research has generally found there's this negative association, meaning the more competition in your area, the less likely you are to provide voluntary innovation disclosure. But what's interesting about our setting specifically is in that patent setting, the technological competition could actually increase the firm's voluntary innovation disclosure, again, with this strategic motivation to potentially preclude your competitors from obtaining a patent so that you can continue to use that technology in the open domain. So this, it is in patent world, and I've got a lot of, sometimes I skip over the institutional details too much because it's kind of becoming second nature to me. So please slow me down if I'm not making enough sense here. But when you apply for a patent, the patent examiner is going to examine your application and decide whether you meet the criteria for obtaining patent protection. And arguably two of the most important criteria that they're looking at is whether your patent meets the novelty criteria, meaning is there another invention already known to mankind that is substantially the same as your current invention, right? If that's the case, then your invention is not novel and it gets rejected for novelty reasons. Another reason your patent might be rejected by the patent examiner is that it's considered obvious in light of what we already know. So if you have to point to maybe 2 or 3 other pieces of information, in patent space, we call this prior art. If you have to point to 2 or 3 findings, and then, but when you put those 2 or 3 findings together, your incremental contribution is just obvious, then your patent gets rejected for being obvious. So when we look to total patent rejections, and again, we know the reason patent examiners make a rejection, approximately 21% of those cite non-patent literature, which a lot of that is going to be academic articles. So including those scientific publications as the basis for rejection, either due to novelty or non-obviousness. So here's an example. This office action summary is what a patent applicant will see when they get their patent back. And it says that claims 1 and 2 are rejected. This is under the novelty clause as being anticipated by this academic journal article. Okay? So that means the patent examiner decided that you should have known this already because it's existing in an academic space, so that now those 2 things that you told me about that were new about your invention get denied. And the application might proceed, but they would have to have a more narrow set of claims. Then in there, it also says that one of skill in the art would immediately envisage the instantly claimed variants of these amino acids as well as their combinations. So again, it's obvious that this invention, given what we already know, so we can't grant a patent on those 2 pieces. If you go to the academic article that paper or that office action cited, we see that one of the employees here worked for Bristol Myers Squibb. So this does have a potential for the corporation of Bristol Myers Squibb to help determine what gets published. So a lot of times when you're employed as an R&D scientist, you're signing your rights of your patents, any inventions that you have, you're assigning those to your employer, and the employer is likely going to have a say in what you can publish that came from you using their resources. What's interesting and kind of important to think about is that this is the timing, right? If we're arguing that firms are going to strategically use their disclosures through this academic article channel to preempt competitors patenting, they need to be able to time their disclosures to some extent. So what may be depressing to accountants that try to publish in our journals, especially here in the US, is that this turnaround time is very much smaller, right, than what we observe in our discipline. So this paper was received in September and accepted for publication 1 month later in October. And we find, I think it's like 67% of the time that the article is published in 3 months or less from the time of submission, and much higher percentages within 6 months. So there is this ability to time your disclosures here.
Yeah, dear Professor Kristen,
Yes.
question from Alicia.
Oh, yes, thank you.
Yeah, hi, Kristen. So very interesting topic. So I was wondering for these employees that are affiliated with for-profit organizations, is it possible that they used to be, say, a PhD student in one of the academic institutions, and this work was developed during the time that they were a PhD student, and so maybe they're affiliated with the other authors, and if the majority of the work was done during their academic training, then maybe they have more of a say in when or to publish and whether to publish their research output rather than the corporations.
Yeah, that is a very good question. And I guess the short answer is I don't have systematic data on how that, how likely that is to be an explanation. One personal anecdote is when I started working at Deloitte as an auditor way back in 2009, I'm old. I had actually wanted to get a PhD and knew I wanted to as a master's student and had started working on an academic research project. And part of my intake forms at Deloitte was, do you have any current papers to, academic papers? And if so, I had to fill out like forms saying that I wasn't going to be using Deloitte resources in order to get that publication generated. But if I had been, then the firm would have had some say or, need some kind of approval before they were able to let that be published. So that, again, I worked for an audit firm. I'm assuming that for, Bristol Myers Squibb or IBM, these where R&D is their bread and butter, they're going to have procedures in place, something probably even more, stringent than that would kind of dictate whether, I think the criteria would be whether or not the employee is using firm resources. If they're using firm resources, then my guess is we're going to observe that as their affiliation. And if so, then the corporation would have more say in that. But there probably are these cases where they've gotten a PhD and are working, and exactly who the affiliation is. I think if we did have that data, I guess what I would want to see is if our results still held after throwing those out. I'm not sure that we have the ability to do that absent a lot of hand collection on when people got PhDs, but it's a really relevant question, so I appreciate you bringing it up.
Thank you. I'm sure it will be a lot of work, but I'd just be kind of interested to know what happens to, after excluding them. But thank you.
Yeah, thank you. So maybe now that we've talked a little bit about the disclosure channel, we can talk about the setting. So the Leahy-Smith America Invents Act of 2011. So this was signed into law in 2011, but the provision that we argue increases technological competition took effect in March of 2013. But the big piece of this law that reformed patenting in the United States was that it moved the United States from a first to invent rule, meaning the first person to invent that technology is granted the patent right. And that is determined based on both public and private evidence. So simply having laboratory notes in your R&D lab that you made a discovery on this date can prove in adjudication with the USPTO later that you were the first inventor. And if there were a patent race, if you invented it first, you would get the patent right. Then the AIA switched to a different rule called the first inventor to file rule. So you still have to be the inventor. You can't just take someone else's disclosure and try to turn that into a patent application and get it before them. But if you're the inventor now in post AIA, you have to be the person who gets the patent is the one who files the patent application first. Okay, so again, signed into law in 2011, took effect in 2013. And what we argue is that by moving the finish line up closer, the AIA put firms that were lagging behind in a patent race at a disadvantage relative to firms that were farther along in their technological progress, right? So if you now that because of the AIA, your incentives have changed, you don't want to race to the discovery, you want to race to file the patent. And it, again, is also going to have different advantages depending on the type of new work you have to do between making the invention and the legal procedures to get ready for filing a patent application. So maybe an easier way to talk about all of this is with a more concrete example. So if we have biologist A, for example, that made a discovery in January and recorded that in her laboratory notes, and then later in May, filed a patent application. Then we have biologist B, who made the same discovery. Maybe, this is a new gene manipulation therapy. They made that in March, but then were quick to file the patent application in April. So under the first to invent regime, so in the pre-period, biologist A would be granted the patent because she can prove she invented that in January, even though it took her longer to get her patent application together. However, biologist B is granted the patent in the post period because he filed his patent application first. So even though he was later to discovery, the application hit sooner. And so he gets the patent right in the post period. Part of the USPTO's motivation for making this law change, I think it was kind of twofold. One is for international harmonization. So the United States was actually the last jurisdiction to have this first to invent rule. Everywhere else, it was a first to file rule, even in our pre-period. I think another reason is it could be costly for the patent office to have to adjudicate these kinds of patent races where you've got to take time and resources and prove and look at private notes. It's really just more efficient and simpler to just look at the application date, and whoever filed first gets the patent, right? Okay, so that's more about the setting. The AIA did change some other things, like how the USPTO was funded. We've got a little bit of prior work in this space, but really I think we're one of the first papers that uses this setting, and certainly the first to look at firms' strategic disclosure responses around the AIA. Okay, so maybe now that we know a little more about the setting, we can talk about what the leader might be doing in their innovative process and the laggard's strategic disclosure response. So if we think about innovation along this timeline, which, certainly innovation is an iterative process, it's not always linear, but generally speaking, right, a firm is going to make an R&D investment. Sometimes those R&D investments are going to pan out, sometimes they won't, but if they're successful, you're going to make some kind of scientific discovery that's truly new and can improve our quality of life. After making a discovery, you're going to have to take some time and get ready to file a patent application. So we're again looking at a sample of firms that are pursuing the types of technology that are best protected through patents. So that's why I think we want to culminate at least in the patent filing in this particular sample. So if you are a laggard, right, and the leader has already kind of gone through the R&D investment, made a discovery, and is getting ready for a patent filing, if you're the laggard pursuing similar technologies in the pre-AIA period, you have only between the time that the leader made the R&D investment and the time the leader made a discovery to make any strategic disclosure, right? Because you have to have your disclosure be in the public domain before the invention date or discovery date in order to preclude your competitor from getting a patent on that technology. Otherwise, the patent office will say, hey, given the prior art, given what we knew at the time of discovery, this was a novel invention and it would still be granted. But in the post-AIA period, the length of time over which your strategic disclosure is effective has been elongated. So you have all the way from when your leader made the R&D investment all the way up until the time they filed a patent. So you can have an additional time period between discovery and patent filing where you are able to develop your invention into the point where you make a scientific publication and still preclude the leader from getting a patent. So the AIA made strategic disclosure particularly salient strategy or more effective strategy for our laggard firms. So our hypothesis is that firms are more likely to increase scientific publications in a laggard technology class than in their non-laggard technology class in response to an increase in technological competition. Okay, so we'll talk about the trade-offs in just a sec, but again, if you can get a patent, you're going to want to get the patent if you think you have a chance. The issue is patents are winner takes all. So if anyone else beats you to that filing date, you're going to lose out on your patent right. If you have a decent idea that you're behind, then you might resort to this strategic disclosure strategy. So some of the benefits of disclosure is, again, that this preemptive disclosure can prevent a rival from obtaining the patent. And that can keep the technology in the public domain so you can continue to use it without paying royalties. But more often than not, it's not just about one individual, genome or one tiny scientific discovery. Innovation is cumulative and builds on itself. So if you have already been investing in this stream of research, maybe you're trying to find an Alzheimer's drug, maybe that's still an important area of research to you. So by by making a scientific publication, you're actually going to extend the patent race for the next invention along this progression towards an Alzheimer's drug. So you could get to the point where you preclude your competitor from patenting, and now even though you may not beat them to that particular invention, you're going to have more time to catch up for the next one, the follow-on innovation. So those are some of the benefits, but what are some of the costs, right? And I think these costs also speak to why leaders don't just all go start publishing scientific articles, even though they're ahead. So the first one we've already talked about, the proprietary costs of disclosing this enabling information to your competitors for your early stage research projects. So the way we're thinking about it is that your scientific publication is going to be relatively less developed than your patent application, right? When you get ready to file for a patent, you're going to want to enumerate exactly what you envision your invention doing and list all of those out, maybe even start reducing some of those to practice. And because the more you can capture of what you think your invention can do and the applications of your invention, the bigger your monopoly rights. So if you disclose something at that earlier stage that makes it harder or easier for your competitors to start thinking about that line of research, that's going to be high proprietary costs. So you really don't want to incur those proprietary costs unless it's your best strategy. And for your leader firm, the one who's guaranteed to get the patent, or at least, probabilistically is most likely to get the patent, you don't want to do that if you don't have to. A second reason, I think, is that it can raise the bar for any subsequent US patent filing. So what it actually does is when you are the inventor, even in the post-AIA period, you still have to file within 12 months of your public disclosure. So it kind of lights the dynamite fuse and the fuse is burning away. And then by the time that fuse goes off, you aren't going to get a patent. So if you have this additional technological development to get to the patent filing. If that takes you more than a year and you've already made a scientific publication, you can't get your US patent. So that's another potential cost for a scientific publication. And finally, like I mentioned earlier, all other foreign jurisdictions were actually under a first to file regime in our pre-period. So and they do not have this 12-month grace period that I just talked about, right? For the US, you have 12 months from your scientific publication to filing a patent, and you can still have the invention. If you're trying to file for patent protection in the US and in Europe and in Japan, right, you're going to have, if you make a public disclosure in a scientific article, that will be used against you in your own patent filing if you're filing in Europe or Japan or another jurisdiction. So potentially you're foregoing international patent protection. So again, because these costs I think are pretty high, you're not going to see everyone engaging in this strategy. All right, so that was kind of all the lead up in the
Dear
background.
Kristen,
Please, yes.
yeah, I have a question. There is another theory you can depend in to explain this relationship.
I'm sorry, can we examine what relationship?
Your hypothesis. There is another theory to you can use it to support your hypothesis.
Okay, you have another argument that can support our hypothesis?
Yeah.
Okay. What argument did you have in mind? Apologies if I'm misunderstanding.
Yeah. Okay. This I asked the theory you use in your study. There is another theory you can use it to support the like agency theory or stakeholder theory. You can use it to support your result.
Okay, the city or setting. So is there another setting besides the AIA we might be able to use?
Yeah.
We could go back and try to see what happened, when the EPA or the EPO, the European Patent Office, or when Japan implemented a first to file system, or if they've always had a first to file system, but that would improve our inferences if we were able to see these first to file regimes taking effect in many different countries. And then we could kind of have staggered implementation across jurisdictions. I'm not, my impression is that it's been quite a while that these jurisdictions have all been in foreign countries, have all been on the first to file system. But I would have to look into that. That's a good idea. Thank you.
Yes, thank you.
Okay, so maybe more of the nitty-gritty of our research design. So in our sample, we're starting with firm years from 2008 to 2010, which we categorize as our pre-period. In 2011 and 2012, we omit those years because in 2011, the act was being discussed, debated, and signed into law. And then the effect of the first to file regime didn't take effect until 2013. So to avoid any anticipatory effects, we removed those years. And then our post period is from 2013 to 2015. And then we start with scientific publications that have been matched to firms, but from this Aurora et al. 2021 data set. So they have coverage of firms that are headquartered in the US, have at least one patent, and positive R&D reported in CompuStat. So that's where we start. We also require firms to have at least one scientific publication in our sample. We exclude the financial industry, as is common, I think, in the strategic disclosure literature. But the Aurora et al. Data set is somewhat limited in that it only maps a firm to the total number of scientific publications, but it does not tell us which scientific publications those are. So we have dug deeper, and this has been the work of the last, 6 or 9 months. I think Wushang's done a great job, and we've hopefully worked together on this, but we've matched now down to using OpenAlex, we can match the detailed scientific publication information for 821 firms. So now we know for a given firm like IBM, how many patents they filed and in which technology areas they were. And we also know how many scientific articles they published and in which scientific field. And so our unit of analysis is about 1.8 million firm year patent class observations. So the US Patent and Trademark Office assigns a technology area to every single patent. And then we also go through and map a scientific field to a patent technology class. So we do that based on patent citations. So when you file a patent application, you're required to disclose the prior art or the prior work that you know about that is in that area. So that can include other patents, that can include scientific articles, and using historical information, we are doing our best to map from patent class to scientific fields, and we say that that's a map if the field is in the top 3 citations for that patent technology area. Okay, so now that we've got that firm technology class year level, we need to decide who is a laggard firm, but more specifically, which are their lagging technology areas, right? So we look at this percentage, we take the total patent stock that a firm has in a given technology class J and divide it by the firm's total patent stock. And by patent stock, we just mean looking back over the past 20 years, which is nice because it kind of corresponds to how long a patent monopoly rights are generally effective if they're always paying their maintenance fees. Over the past 20 years, where was the firm granted patents, right? So they could be granted patents in technology classes A, B, and C. And if, 2/3 of their patents were granted in technology class A, they're going to have a higher percentage in that technology class. So given that firm tech class percentage, then we're going to start categorizing where firms are in their investment relative to their peers. So you could think about firm 1 that has a patent filing in the given year in technology class A. Over the past 20 years, they've had 9 patents in that technology area. And for them, that represents a percentage of 90% of their total patent stock. If we look to everyone that has patented in that technology class, the 25th percentile is 30%. So this firm 1 has 90% of their investment in technology class A, and everyone else is only investing 30% of their resources there. So they are not, firm 1 is not a laggard in technology class A. But in technology class B, the firm still has a patent filing. They only have 1 patent over the last 20 years in this area. And everyone else in the technology area at the 25th percentile has 20% or invested. So because their patent stock is less than the 25th percentile, we're calling this a lagging technology class. Again, we're trying to say, where are you devoting your resources? If it's if your investment is relative to your competitors in the bottom 25th percentile, that's your lagging technology area. Something else we do take pains to is there are going to be some firms, since our number of observations is at the firm technology class year level, we're including all potential technology classes for every firm. So some of them might not ever patent in that technology area over our sample period. And we don't want to call a firm as a laggard if they just don't even operate in that technology area, right? So what we do is we require a firm to at least have a patent filing in any one of our pre-period years. But with respect to this year, year T, like firm 2 doesn't have a patent filing there, but their stock is less than the 25th percentile. So we are not calling that firm a laggard. Because again, they're just really, if they don't file a patent in that year, they're not really operating in that space. So our main treatment variable is called laggard pre, and it takes on the value of 1 when our laggard class is 1 for any pre-period year. So if you file a patent in 2008, 9, or 10, and in that area, that lets us know you're at least operating in that area. And if that's the case, but you're investing less than the 25th percentile, that is a lagging technology area for you. And we do some robustness checks on this measure, but hopefully that makes some sense on how we construct our laggard, our treatment variable. So having defined our treatment unit of observation, this is our main research design. So our outcome of interest is the scientific publications, the number of scientific publications that we take the log transformation for with skewness. Then we interact our treatment with post. And then we have firm by year fixed effects, firm by tech class fixed effects, and tech class by year fixed effects. So we can talk through how to interpret each of those, but beta 1 is our coefficient of interest, and it captures changes in a firm's scientific publications in that lagging technology area after the AIA, and that is relative to the scientific publications the firm makes in other tech classes in that same year. So we're comparing within a firm in a given year what they're publishing in their lagging area versus other areas. So this should not be just kind of some firm-specific event that's driving our results. And then additionally, with our other fixed effects, this is incremental to the average level of scientific publications that a firm makes over the sample period in that tech class. So if they always have a higher level of scientific publications in a technology area, that's going to be captured by that fixed effect. And then it also is going to, this tech class by year fixed effect will subsume any trends in scientific publications that are particular to that tech class year. So if we just have a really hot pharmaceutical drug in Alzheimer's year, maybe we're going to see more publications in that area. That tech class by year fixed effect will take care of that. So just to quickly preview the results, and then I can show you the tables. Our results summary, I think first we kind of validate this measure of our laggard firm. I know we had to walk through several steps to get there, so we want to make sure we got it right. We do find that firms are decreasing the number of patents filed in their lagging technology area after the AIA or that they even exit that technology area entirely. So they aren't patenting at all in the post period. So I think that kind of validates that our measure is capturing the firms that were lagging behind because they're rationally reducing their patents or exiting the area. Our main result, we find that firms do increase their scientific publications in their lagging technology areas after the AIA. And our cross-sectional tests find that the effect is present or even stronger for firms that have high inventor mobility. So the idea here is that you have a better idea of where you stand relative to your competitors if you can maybe hire some of your competitors' employees. The effect is stronger for firms that are more focused on US patent protection. Again, foreign jurisdictions already had this first to file rule. So looking at those that care a lot about the US is where we find our effect. It's also stronger for financially constrained firms, right? Because one potential strategy is if you're lagging behind is just throw money at the problem. If you can't, because you're constrained, the effect is stronger. Also, because we're really kind of homing in on this time between when you make a discovery and when you make a patent filing, we think that legal expertise in that patenting area is going to be highly relevant. So if there are technology areas where the supply of experienced attorneys is low, so you aren't going to be able to, again, kind of just hire someone that's more specific to that area to help you get your patent filed faster, that's where our effect is also stronger. And then finally, if there's more competition in that technology area, meaning you're more likely to actually be engaged in a patent race, that's where our effect is strongest as well. Then for some robustness tests, we do alternative versions of laggard firms or laggard classes. So we'll, instead of just looking at your percentage of your patent stock, we just count the number of patents. So our main measure kind of size adjusts, the count measure does not. But you could argue that, hey, if I filed 10 patents, I'm still more experienced than someone that's only filed one, regardless of what percentage of investment that looks at. So our results are robust to that. And then we also value weight the patents. So it could be that, you know, the number of patents we kind of are implicitly assuming that every patent is of equal importance, but we know with innovation, they have high outcome variability, right? Some patents are really valuable. Some patents don't end up having any value. So when we evaluate, we still continue to see their results persist. And again, when we map the technology class for the patent to the scientific publication field, that could, you know, that's something we, to our knowledge, hasn't been done in the literature before. So we kind of, you know, unscientifically saying made it up, right? We think it's totally reasonable based on actual citations, but we want to make sure our results are robust to different types of mapping strategies. And then finally, if we randomly assign the laggard technology area within a firm, we don't see our results presenting. So it, again, does not appear to be some specific firm characteristic. And then finally, the consequences, which I think are probably the most interesting, is that we observed an increase in patent rejections for novelty and non-obviousness reasons in the post-AIA period for the peers that have been affected by our firm's lagging technology areas, right? So our treatment firms that were lagging behind and published more, the peers that publish in that try to patent in that technology area are rejected more often for novelty and non-obviousness reasons. And that's as a percentage of total rejections and controlling for the level of patent filings in that area. Right. So now we can kind of dive into the individual results, but I think our descriptive statistics, and I think I saw Mohamed put out a link on SSRN. This is all kind of new, this firm tech class year unit of analysis. So the table references aren't going to jive with what we have on SSRN currently, though we hope to have an update out there pretty soon. But if you look, on average, firms in our sample have about 38 scientific publications in 9 different technology fields. And then in our pre-period, firms are filing patents in 13.5 different technology classes, of which about 4 of them are categorized as lagging technology areas. So less than a third of firms' technology classes are classified as being a lagging area on average. Then we walk through our validation results. First, we're looking at the number of patent filings. So for firms lagging technology areas, in the post period, we find they're filing fewer patents. And really all of these different we layer on our fixed effects so that we can have more confidence that, the result is there and that it's not an artifact of a specific fixed effect structure. So this result is there even without any fixed effect. It's there with firm, year, and tech class fixed effects, and then we kind of layer it on to what our main specification is where possible through the rest of our tests, which is that dense fixed effect structure, where we're looking within a firm year across their different technology areas, controlling for their average tech class activity, and controlling for any tech class specific trends for that year. And then we also find that you are more likely to just exit, meaning this is an indicator for whether or not you patented at all in that technology area. So again, table 3, I think taken together, this tells us that our definition of laggard technology areas is likely capturing firms that are behind in the patent race and therefore rationally exiting or decreasing their activity in that area. Okay, now table 4 is our main result. We do find that in your lagging technology area, the firm is going to increase their scientific publications in the post period. Whoops, I'm so sorry. All right, you seeing everything okay again? Sorry. So they're doing that relative to the other technology areas. So on average, kind of the magnitude here is that treated firm years have 4 more scientific publications in the post-AIA period. We'll give some more context to that when we look to peers, but it is possible for one scientific publication to block multiple patents. So unfortunately, we don't have a database for this. We can't give you systematic evidence, but we do have some anecdotes where one patent blocked 14 different patents, or one publication blocked 5 different patents. So this could, even though 4 doesn't sound like a huge change, I think given what we saw for, I think on average they have like 38 publications, I think that's still material relative to the mean and also can have an outsized effect on peers. And then because this is a difference in differences design, we do look to a parallel trend analysis to see that there's no pre-period trend. And then this increase in publications does persist throughout the post period. Okay, so for our individual cross-sectional cuts, when we look at inventor mobility, again, this expectation is that firms can more readily hire competitors' employees. And if that's the case, then they have a greater knowledge of where they are positioned in the patent race. So again, because of the high costs of scientific publications, if you have better knowledge of where you're positioned, you're going to be more confident and kind of use that strategy more often. So we have 2 types that we look at. One is the low IDD. So IDD is the inevitable disclosure doctrine. This is kind of this legal framework that is implemented at the state level in the United States. And there are differences across states, but basically the inevitable disclosure doctrine says, hey, I'm a firm, I have these trade secrets that my inventors have been working on. The inevitable disclosure doctrine makes it harder you can kind of tell the firm, harder for your competitors to hire your former employees, because you can argue that it would be inevitable that if that employee worked for my competitor, they would reveal their trade secrets. And you can preclude your former employee to going to your competitor, even without evidence of actual disclosure. You could just argue it's inevitable it would be disclosed, so you can't let them work for that firm. And if you're in a high IDD state, then you're not going to see as much inventor movement. But if you're in a low IDD state, you will see more inventor movement. So we look to where firms' R&D scientists are employed and the percentage of their R&D scientists, if their exposure is in low IDD states, that's where there's more inventor mobility. That's where we see our results being stronger. So this is kind of a nice setting because you can assume at least within our narrow window, it's unlikely that firms are up and moving their R&D labs across the country just to, in response to the AIA in our narrow window. So it's kind of more exogenous. But in a more endogenous version, we look at actual inventor movements, and we can track that by seeing where inventors are affiliated when they file a patent application. So we can observe the individual inventors on a patent and who the organization was. And if there's a lot of movement that's in that technology area, that's where we're seeing it. So again, the idea is if you can have better knowledge of where you are, the results are stronger. Okay, the next category we look at is firms for whom foreign patenting is important are less impacted by the AIA because they were already trying to file patents as soon as possible to get patent protection in foreign jurisdictions. They're less likely to be affected by the AIA. So if we look at if you have any for any invention, if you file that in other jurisdictions, it's strong. The effect is stronger for firms that are just local predominantly versus also have foreign. Or if you file in a foreign jurisdiction first, then we actually don't see the effect, right? But if you only file in the US first, that's where we see the effect. Then looking to financial constraints, again, the intuition that financially constrained firms are less able to increase their resource allocation, so shift to their lagging technology area because they're cash constrained. We use leverage and debt to cash ratio at the firm level and find that when you have high financial constraints, you're more likely to use strategic disclosure. Okay, I think the next one we look at is in our technology class characteristics, right? So the ones I was looking at before are more firm unit of analysis, but now we can get even more granular. So the expectation on access to legal expertise is that when you have less access to experienced attorneys in a technology area, firms are less able to file their patents quickly in response to the AIA, right? Because you need that legal expertise to go from discovery to patent filing. If you don't have an expert in the area, it's going to take you longer to get there. And that is the case. We do find that the results are concentrated in technology areas where there are fewer experienced attorneys available. And then the second technology class level we look at are kind of barriers to entry or competition. So the expectation is that preemptive disclosure is going to be more important or more prevalent when competition is greater. So if you don't have a lot of competing technology or competing rivals for the same technology, you don't really care who wins the patent race. Like you're writing a paper that no one's going to compete with, so you don't have to worry about it as much. So we do find if you have a higher concentration of people in that technology area or a higher number of competitors, that's where our results are strongest. Okay, so our robustness test, I think I mentioned, if we use the count instead of the relative percentage, we still see our results holding. If we're value weighting the patents based on this Kogan et al. KPSS value, so that's the grant date fair value, that based on the market reaction on the date of grant, and we weight by that, our results still hold. If we use forward citations for those patents, our results continue to hold. And then we also look at alternative rankings. So if we map a field to a technology class at a patent level from scientific publications to patents when they're in the top 3. If instead we use the top 1 or the top 5, or they have to have represent at least 5% of the citations in that technology area, all of those seem to give us the same answer, right? That firms are going to increase publications in their lagging technology areas. And then here's this falsification test where we randomly shuffle the technology area that we define as laggard across a firm in a given year. And we do that, I think, 1,000 different times. And we find that, the coefficient is essentially 0, which compared to what we actually find, it's very likely that our results are not just spurious, or in other words, a result of some omitted firm characteristic. Right, so for peers, kind of the consequences, if I've convinced you that firms are increasing scientific publications in their lagging technology areas, then we want to say, so what? What does this really matter? We do find that when we look to those technology areas where a firm is lagging behind, where we previously saw greater scientific publications, that peers that patent in this technology area have an increasing percent of their applications rejected for novelty reasons, or so they're not deemed novel, or they are deemed obvious, right? So they're rejected more often. And this is controlling for the total number of patent applications. So even if, regardless if there's a high level of rejections or a high level of volume, we're kind of controlling for that. And then this is, again, a percentage of total rejections. So the share of rejections due to these reasons where the patent examiner is citing prior art, like scientific publications, is increasing. So in terms of economic magnitudes, the novelty or rejections increase by about 2%, which is approximately 4 incremental rejections. For obviousness reasons, it increases by about 6% relative to the mean, which is an increase in rejections of 18 different patents. And this Kogan et al. Data does kind of look to the dollar value of a patent and finds that the median patent value adjusted to today's dollars is about $10 million. So, anywhere from 4 to 18 new patent rejections across these peers still can add up to something material. So you might be asking yourself, okay, if these leaders are so smart, why don't they do something about this strategy? And we have started looking at this. If you compare with, we just now instead are replacing our dependent variable to be the leader's patenting activity. So if we compare the leaders, I guess better said the non-laggard, or these are all the peers, the peers of our laggard firms. So if you file patents in the technology area, you are actually going to be increasing your patent filings in technology areas where you do not lag behind in the post period relative to our pre-period. So they do seem to think, hey, I am ahead in the race, I'm going to patent some more, and that should be good for me. Then our prior table says it looks like they're getting rejected more often. So if we then look a little farther ahead in time and instead compare the next 3 years after our post period, so 2016 to 2018, to that immediate response where we saw more patent rejections, we actually do see that if these peers actually decreasing the number of patents that they file. And again, that's economically meaningful. So peers initially increase their patent filings by about 22 patents, but then reduce their new patent filings by about 7 patents. So it does seem to be like this game theoretic response where peers are responding to this increase in scientific publications. Right, so in conclusion, and I'm welcome to take more questions after too, we find that laggard firms appear to use their scientific publications as a strategic disclosure mechanism after the AIA induced a race to the patent office, and that these scientific disclosures increase peers' patent rejections, and that those peers are changing their patenting behavior as a result. So we think our paper has implications for regulators interested in doing a post-AIA review. Maybe it's a good thing that there is, from a societal perspective, that there is more knowledge out there if we see more scientific publications, but there's also some evidence that firms are kind of changing how they innovate, and that could have broader consequences as well. And I think we also contribute to our disclosure literature and accounting on the effects of technological competition. But thank you very much for your attention.
Yeah, thank you very much, dear Professor Kristen, for your contribution and your effort. It's really an excellent presentation and excellent paper. Thank you very much for this. Now, if anyone have any questions, you can open your mic and ask your question. If anyone have any questions, yes. John J, you can ask.
Okay, hello. Can I ask two questions? The first, regarding to this effects of competition. I remember it's what in table 7. You divide the sample into two groups. Uh, um. No. 7 or 8. The effects, the moderating effects of competition. No.
I think this is the competition. So then the concentration and the number of competitors.
Yeah. The column 3 and 4. I remember we have a very good paper from Agan and Bloom, 2002, about the U-shape of competition and innovation. So I wonder if if you divide the sample into two groups, low and high competition, maybe two quarters. Should we try? Yeah.
Yeah, I'll have to. So you said Ayer and Bloom 2002?
Yeah.
Okay.
They found an U-shape, invert U-shape relationship. So probably we can divide our you can divide our sample in smaller subsample to see whether the linear relationship still hold.
Okay, no, that's a good idea. I'll have to look that paper up. I appreciate the reference. Yeah, certainly these are all admittedly coarse. I think for all of these cross-sectional cuts, we're just splitting on the median. We kind of do that to be consistent, but competition is certainly one of these multifaceted animals, right? So it's, maybe too coarse. So I appreciate that. Thank you.
Yeah. And the second question I have is about the attribute of patents. We have exploiting and exploring patents. Did you consider the differences?
No, that's a great point. So I know like the strategy literature speaks a lot more to this, where we have exploratory innovation. So these are like the new big breakthrough innovations, and then exploitative innovation are these tiny kind of marginal effects, right?
Yeah.
And so I think really all we have currently in our results that speaks to this directly are these kind of value-weighted versions of our measures. So if we do find, if you're going to buy the idea that higher citations or higher market reactions on the date of grant could also proxy for more valuable innovations that are maybe more likely to be this exploitative type of innovation, if we are weighting firms' contributions across their technology areas based on value, we do still see our results presenting, meaning that firms, if they're lagging based in the terms of value on those patents and not just the raw count, that's where we see it happening.
Yeah. Agree. Kogan measure and citation measures also very good proxy for the quality of the patents. But actually I found very few paper directly compare Kogan measure and citation to these exploring and exploiting attributes of patent. I think that it's good if you can test, and it's very interesting if the finding is quite new.
Yeah, and I have seen different definitions of how to define exploratory and exploitative. Sometimes they are citation based. So yeah, if you have a specific paper or measure that you like, I'd be happy to write, if you put that message in the chat or email me, I'd be happy to look at that paper. Because we could define our laggard firms this way, but another way to use this idea could be to look at like our table 3 result and see how it changes our
Yeah.
changes
Yeah.
the laggard
Yeah.
firm. Yeah.
Actually, I'm online on phone now. Tomorrow, when I get into my laptop, I will send you
That
several
would be great.
papers.
Yeah.
Yeah.
Yeah,
Yeah.
I have
Thank you.
that language in some other work, but we haven't brought it in here yet. So thank you.
Yeah. Thank you very much. Actually, I do 2 papers on patent as well,
Oh,
and
wonderful.
yeah, and Bo Hu Zhang, I met him one in 2020, and he said that so patent that you shouldn't follow that. But today, when I see the presentation, I think that's patent and innovation in general, not that very comprehensive study, and I think that you will find a very good publication, a very good journal for this.
Oh, thank you. Appreciate that.
Yeah, thank you.
Another question, Alish? Alish, you have a question? Yeah.
Oh yeah, sorry, Kristen, I just have more of a clarification question. So for the rejections, are you able to see whether the rejecting reason was linked to the scientific publication? Do they cite it?
So I guess yes, but not in a systematic way that we feel confident for. So like I did show you that one example, right? The office, patent office. So like it is feasible that if we pulled up every single document in the first office action rejections, that we could see what they're citing and try to link that to our database. But it's going to be costly again. So I love your granular thinking, because I'm with you. Like, we're accountants, we're all about measurement and getting the measurement right. We're just not sure that that data collection is going to be worth the cost benefit to us. So all we can really say right now is that where we see the increase in scientific publications among these lagging technology areas, we're also seeing peers getting rejected more for these non-novelty and non-obviousness reasons. But we can't say right now that there's that mapping, because some of the difficulty there is, I think that one that I showed you was like Larson et al. And it gave us the journal, but the text there is just going to be really hard to parse. Like, I think it would require just kind of manually looking at all of that and then mapping it to the individual scientific publication. So what's great is if it was a patent, I could do this, because we do have a data where they list the patent number that the patent office is rejecting this certain application for. And then I have a unique patent number. I know exactly which patent I'm talking about. The inherent problem is there's no unique identifier for a scientific publication. So it would be a manual matching process, and there's just a lot of non-standard issues there. So really, we just have some anecdotes right now.
Yeah, thank you. Yeah, I'm sure it's a lot of work to hand collect all these information, and it's just more of my own understanding in cases of it. Or if it's like, too much additional work, I'm not sure if it's, that
but yes,
valuable.
it is possible to observe it. Yeah.
Also, I wonder, like, for the scientific publication, when firms file these, like when they have these publications, is there like kind of positive market reaction, kind of like the patent filing? So they would benefit from filing, from having these publications, even if there is no strategic value, they would still want to push out their innovation because the market would recognize that there is value to it.
Yeah, that's a good question. So we haven't looked at that. Though I know the Aurora et al. 2021 paper sees that when there's more like analyst demand for information is where we see more of these scientific publications. Maybe Wushang, do you remember if that paper looks at market reactions or not? I don't know that they do, but that would be interesting. That's very reasonable, because for these firms, innovation should be very important. So the additional disclosure could have capital market benefits, as well as, this deterrent effect that we're focused on. I think that's a good point.
The reason I'm asking these questions is I'm thinking another reason this could be happening is that the leaders in these innovation, because now if they file patents quickly, they can just grab the rights to these patents, right? So they would just want to file as many patents as possible, and then the laggers are sort of squeezed out, and their second best choice that they still get some benefit, maybe from the capital market, maybe perhaps in addition to the strategic value, they would still file kind of want to have these scientific publications, even if there is no strategic benefit. So I'm not sure if that's a kind of reasonable thing that could be happening. If the market doesn't recognize there is value, then probably they won't want to have these publication, but perhaps this is like their second best strategy for these laggard firms.
Yeah, that's a great idea. We could think about that. I think it would just kind of add more into the bucket of benefits. And because we did talk about on the hypothesis slide, like the benefits and the costs. And so if there are capital market benefits, that would be another benefit for these firms. Yeah.
Very interesting paper. Thank you.
Oh, thank you. Great questions.
Are there other questions? If anyone have any questions, you can open your mic and ask your question. Thank you very much, dear Professor Kristen, for your contribution and your effort. Thank you very much. Thank you very much, everyone joining us today, and thank you very much, dear Professor Kristen, for taking the time to present it to us today. It's been really appreciated. Thank you very much.
Oh, thank you. It's such an honor. Really appreciate it.
Yeah, and I hope to see you soon in Egypt. You are very, very welcome.
Thank you.
Yeah.
Rồi.